Good evening. My name is David Ormerod and I am the co-director, along with Professor Cheryl Thomas, of the Judicial Institute. Welcome to those of you here in person and online. It's my pleasure to introduce our speaker, Dominic Grieve, King's Counsel, to deliver the Brian Leveson Lecture. Sir Brian Leveson was one of the most influential judges in the English courts in recent decades. He served as the senior presiding judge, as president of the then Queen's Bench Division, and as head of criminal justice. He became a household name following his inquiry into press, culture, ethics and practices. In 2019, on his retirement from the bench, we were privileged when he delivered a valedictory lecture here at the Judicial Institute, celebrating his 50 years in the law. On that occasion, we were also delighted to announce the inauguration of the annual Leveson Lecture series. Unfortunately, then COVID put paid to our plans for future lectures. It's therefore a real delight to introduce our speaker this evening, the Right Honourable Dominic Grieve, King's Counsel. His topic this evening is blaming the judges. What is the problem with our politicians when it comes to the law? I see the title and I feel obliged to warn you, Dominic, that we only have an hour. More seriously, it's difficult to think of anyone better placed to speak on this topic. Dominic is a barrister called to the bar in 1980 at Middle Temple. His practice was largely in criminal and regulatory work and a true common law practice. He was appointed Queen's Counsel in 2008 and subsequently, of course, as the Attorney General, he headed the Bar of England and Wales. He now practices from Temple Garden Chambers and is still actively involved in the profession. I know this because he and I spent a weekend delivering training on advocacy for student barristers just a few days ago. As a politician, Dominic served as the Conservative MP for Beaconsfield for over 22 years. He held positions as the Shadow Attorney General, Shadow Justice Secretary, and then in the coalition government in 2010, he was appointed as the Attorney General and sat in Cabinet. In that role, of course, he was the Chief Legal Advisor to the Crown and responsible for delivering legal advice on all manner of topics. No easy task. It's fair to say that Dominic was universally respected in that role. That is so clearly demonstrated by the comments made in the House of Commons the day after he was removed from his post as attorney in a cabinet reshuffle in 2014. Jack Straw, speaking from the opposition front bench, posed the following to the Prime Minister. It is fundamental, is it not, that the holder of the office of Attorney General should be fiercely independent, defend the rule of law, and be ready to speak legal truth to power. Given the distinction and respect with which the office holder, Dominic Grieve, pursued that role, what possessed the Prime Minister to dismiss him yesterday? In 2019, Dominic Grieve left the House of Commons, but not before galvanising various forces in their opposition to Brexit and displaying skills in using the labyrinthine parliamentary processes in his determination to secure and engineer various debates. His new roles since leaving the Commons include being a visiting professor of law, politics and human rights at Goldsmiths, and he continues to secure respect across the political divide. You can be confident of that when you read articles in The Guardian referring to him as heroic for his sustained stance on the European Convention on Human Rights, Brexit, and his work chairing the Intelligence and Security Committee in Parliament. We are fortunate indeed in having Dominic as our speaker to deliver the Brian Leveson Lecture 2022. Dominic.
Well, thank you, Professor Ormerod, very much for that very kind introduction. It's a great pleasure to have been invited here this evening to give this talk, and all the more so because it takes its name from Sir Brian Leveson, a fellow bencher of the Middle Temple. And I have to say that my view, in his judicial career, he's epitomised, for me, sometimes in the face of very poor behaviour of politicians, the highest standards of conduct that we too often take for granted in judges, but politicians too often neglect to openly support. When it was first proposed to me to come this evening, the idea was that I should talk about the government's new Bill of Rights and its likely impact both domestically and internationally. Now, that issue is, of course, for me, something of an old song, because the first time I came to give a talk at UCL was shortly after being dismissed from office as Attorney General in 2014 over that very issue. And David Cameron, as Prime Minister, had decided that the Conservative Party manifesto of 2015 would contain a commitment to scrapping the Human Rights Act and replacing it with a British Bill of Rights that sought to limit the scope of how the European Convention on Human Rights was interpreted in our own domestic courts. As I disagreed with this policy, he dispensed with my services. But 8 years and 3 prime ministers later, each of whom has expressed similar irritation and hostility towards the Human Rights Act, we still have it. And the latest proposals for change were brought in under Boris Johnson, then dropped by Liz Truss when she became Prime Minister as a, quote, complete mess. But the threat of change, including, if we listen to the Home Secretary, pulling out of the convention altogether, remains. And the complete mess has now returned with Dominic Raab as Secretary of State for Justice. This instability made me think that I might better leave it to others to analyse in detail the proposed Bill of Rights. It might, however, be the opportunity instead for a more personal reflection on the phenomenon that's given rise to this long-running saga over the Human Rights Act, as well as other areas of tension between politicians and the law, a tension that certainly affected my career in politics. I want to examine why some politicians and their linked circle of supporters, which includes policymakers, party members, journalists, have become irritated by and critical of the operation of the rule of law as we currently have it, and of the judicial decisions that underpin it. I also want to look at the consequences that have flowed from this and what, if anything, might be done about it. Now, in the course of 22 years in the House of Commons, I can't recall any politician, or indeed law-abiding member of the public, who didn't believe in the principle of judicial independence and the rule of law as an abstract concept. The United Kingdom's judiciary is rightly held in high esteem for its lack of corruption and its independence from other branches of government. There's also almost universal pride in the existence of a legal system that has a good global reputation for seeking to deliver justice and the rule of law. The presence of retired UK judges on the benches of international commercial courts is viewed favourably. Successive governments have used our judiciary and legal system to promote UK soft power. As Attorney General, I travelled to the Gulf, to the occupied Palestinian territories as part of such programmes, in which former judges also helped. 2015, the then government supported financially the Global Law Conference in London that both promoted the rule of law and showcased our own contribution to it. Nevertheless, such appreciation doesn't mean that all judicial decision-making is universally applauded. The interpretation and application of the law may be the preserve of the courts, but Parliament's the law-making body, and the executive, which is bound by the law, has an entirely legitimate interest in its operation. As judges know and have to accept, the decisions they make are open to comment and criticism. But while criticism ought to be tempered by an awareness of the need to show respect for the separation of powers, the reality is that politicians find it hard to do this if a particular judicial decision appears adverse to their own opinion and that of sections of the electorate or the media to whom they look for approval and support. This has become much more so in an age when politicians come under growing pressure from social media to comment and take sides daily on a myriad of controversial topics. I think a good example of this trend can be seen in the history of what came to be known as super injunctions. These have actually been used very sparingly by the courts interim measures to restrain the publishing of information which is being plausibly alleged to be confidential and private, and further to prohibit the publication of the existence of the order on the ground that otherwise its purpose would be undermined. It's always been recognised they're exceptional. Unsurprisingly, however, the orders have also been objected to by sections of the press and public as they've prevented the reporting of the names of litigants and the background of cases, often of real public interest. In 2011, this led to an MP, John Hemming, using and abusing parliamentary privilege to circumvent an anonymised injunction. It happened 2 years after the decision in the Trafigura case, which had encouraged the incorrect belief amongst some MPs and journalists that the courts were trying to gag Parliament in breach of the Bill of Rights of 1689, notwithstanding an intervention from Lord Judge explaining that this was simply not the case. The senior judiciary then responded promptly, set up an inquiry by Lord Neuberger to report on the use of such injunctions. The publication of his findings largely brought the controversy to an end. But the episode illustrates the problem that can arise if judicial decisions are seen as flawed or objectionable by parliamentarians. The consequent potential for confrontation, the loss of comity between Parliament and the courts, and the temptation to abuse parliamentary privilege can lead to the undermining of the rule of law. Such tensions are going at times to be inevitable. The workings of parliamentary democracy are always going to have a chaotic fringe. Freedom of expression can come into conflict with rules that underpin the operation of the courts. But the majority of parliamentarians have normally refrained from jumping on such bandwagons, and successive speakers of the Commons have sought to prevent abuses of parliamentary privilege. As long as those parliamentarians who are also members of the executive support the rule of law and are capable of mediating and resolving such issues, the problem is in the long term a relatively minor one, just as is the intemperate criticism of judicial decisions from the same source. I've always been struck by the fact that members of the judiciary, who weigh their words carefully, can continue to be concerned about the comments of politicians long after the politicians have forgotten they ever made them. But the issue is different if it's the politicians who are members of the government who take the lead in attacking judges and the legal framework within which they operate. Although ministers and other political leaders may in past generations have had reason to be irritated with the way the law was interpreted and applied, it's only more recently that there's emerged amongst them a persistent, almost endemic frustration with legal constraints. It's now claimed that such constraints impinge so as to make it difficult for governments to govern in what is claimed to be the widest public interest. The claim centres in particular on the belief that there is an overemphasis on individual rights at the expense of the rights of the majority, whose views are therefore being ignored, thus undermining democratic legitimacy. There's almost an assumption that what is not, quote, democratic has no value. With a few exceptions, the basis for the expressed concerns is not rooted in standalone judicial decisions. Rather, and ironically, they are the result of the choices of successive democratic governments since the end of the Second World War to accept the constraints on how a government should behave towards those subject to its authority, imposed in part by the multiple international legal obligations they themselves have voluntarily entered into. Some of these have then become expressly incorporated by legislation into our domestic law. They thus become directly enforceable through our courts. This effect is a consequence that was both predictable and predicted. When the United Kingdom signed up to the European Convention on Human Rights, the 10 key rights originally protected under the Convention were, with the exception of Article 8 on privacy and family life, a classic exposition of the liberties which successive generations of British politicians and the British public have claimed as our shared and exceptional inheritance. Those rights fit with a romanticised national narrative traceable back through the Bill of Rights of 1689 via habeas corpus to Magna Carta. But there is, of course, a big difference between that tradition and the effect of signing up to an international legal obligation that has to be interpreted as a last resort by an international tribunal. The then Labour Lord Chancellor Lord Jowett feared that, quote, the real vice of the document consists in its lack of precision. Contemporary Foreign and Commonwealth Office advice to ministers on signing the ECHR was against it. They argued that, quote, to allow governments to become the object of such potentially vague charges by individuals is to invite communists, crooks and cranks of every type to bring actions. 70 years on, it's striking how the same themes keep on repeating themselves. Early adverse decisions of the European Court were tolerated even if not welcomed by some politicians. An example is the judgment in Campbell and Cousins in 1982 that effectively triggered the end of corporal punishment in schools. Mrs. Thatcher told her whips to push it through the House of Commons while she herself went off to have dinner with Nancy Reagan so that she could avoid voting on it. But by the early 1990s, there was a significant change in political attitudes. Michael Howard, as Home Secretary, complained of the decision of the European Court in Shahal to prevent the deportation of a suspected Sikh terrorist to India on the grounds of the risk of torture, and despite the assurances he had secured. He alleged it usurped a decision that ought to have been left to the executive. The attitude coloured the Conservative Party's approach to incorporation of the ECHR through the Human Rights Act, even if at the end of the legislative process the party's policy was not to vote against it at third reading in 1998. By 2015, during that widely celebrated 800th anniversary of Magna Carta, David Cameron, who had been Howard's special advisor at the time of Shahal, was happy both to praise the Charter and the principles undermining the Convention. Yet he had in the preceding month published a Conservative Party position paper that asserted that, quote, both the practice of the European Court and the domestic legislation passed by Labour, that's the Human Rights Act, has damaged the credibility of rights at home. The European Court was accused of subverting the intention of the Convention's draftsman by developing its jurisprudence outside the alleged scope of its remit. Talk of fundamental change, with at its heart an intention to repeal the Human Rights Act and replace it by a British Bill of Rights which would, quote, clarify rights, particularly those under Articles 3 and 8, so as to prevent their abuse in deportation challenges by changing the test to be applied. The Convention rights were to be confined to, quote, cases that involve criminal law and the liberty of the individual and other serious matters, with Parliament setting a threshold below which no Convention right would be enforceable. Also sought to break the link between the jurisprudence of Strasbourg and our own, so that no account need be taken in this jurisdiction of that court's rulings. The United Kingdom was to demand a special status, where judgments of the European Court of Human Rights were merely advisory, or else, if this couldn't be achieved, we would leave the Convention. That would then leave us with a domestic Bill of Rights with all potential areas of irritation for the executive conveniently removed. As was pointed out by many at the time, the proposal contained serious factual errors and consequential defects in argument. It was widely criticised, but it still featured in the 2015 Conservative manifesto, but never went anywhere until substantially revived with some very minor variations by the present Justice Secretary Dominic Grieve in his current British Bill of Rights. This bill, and the minor changes brought into the operation of judicial review through the Judicial Review and Courts Act, is, I think, driven much more by recent events than past sources of hostility to the Convention. I know that in 2015, the Conservative Party had found, to its considerable surprise, that in private polling, only 16% of the electorate considered that repealing the Human Rights Act was even in their top 10 priorities. They should not have been surprised. After the Brighton Declaration of 2012, there was a significant diminution in the number of UK cases before the European Court, and perhaps consequently much less media comment about its operation. Prisoner voting standoff, resolved by David Lidington as Lord Chancellor, without the need for primary legislation at all, and without any domestic political fallout. Whilst there are some continuing friction over deportation and asylum, and the impact of the Convention on military operations abroad, there were far fewer complaints about judicial activism. Indeed, I think the last figure I've just seen today is there were 2 cases which were successful against the United Kingdom in this calendar year. However, the Conservative Manifesto of 2019, written in the aftermath of the 2 decisions of the Supreme Court in the Miller cases, is directed at the new sources of political grievance that spring directly from the Brexit process. This focused on, quote, the relationship between Parliament, government and the courts, the functioning of the royal prerogative, the role of the House of Lords, and somewhat bizarrely in the circumstances, access to justice for ordinary people. It pledged to update, I quote, the HRA and administrative law to ensure that there is a proper balance between the rights of individuals, our vital national security and effective government. It went on. We will ensure that judicial review is available to protect the right of the individuals, I think that's a typographical error in the manifesto, against an overbearing state, while ensuring this is not abused to conduct politics by another means and to create endless delays. No hint of recognition by the government then or since that the Supreme Court, in ruling that the initiation of the Brexit process must be by primary legislation rather than under a prerogative power, and by checking the executive's abuse of the prerogative to prorogue Parliament for 6 weeks in the middle of a political crisis for the express purpose of avoiding parliamentary scrutiny, might have been protecting those very rights referred to in the 2019 manifesto and indeed parliamentary democracy itself. Instead, the 2019 manifesto and the government's attitude to the Miller decisions seems to mark the development of a rather novel constitutional principle that governments enjoying the confidence of a parliamentary majority have essentially a popular mandate to do whatever they like, and that any obstruction of this is unacceptable. There was also, more reasonably, the promise of a, quote, Constitution, Democracy and Rights Commission to look in depth at all these issues and come up with proposals, quote, to restore trust in our institutions. Now that sounded of some interest, but like most Johnson promises, such a commission has never materialised. It's been replaced instead by the piecemeal reviews of human rights and judicial review, followed in the case of judicial review by very minor reform, and in the case of human rights, legislation which disregards the cautious and very well-reasoned ideas of the independent panel which had been chaired by Sir Peter Gross. In regard to the nation's security, the Overseas Operations Act 2021, which was intended to end vexatious claims against UK armed forces personnel, can also be counted as a consequence of the 2019 manifesto promises. Denounced by a former chief of the General Staff as contrary to every principle for which the armed forces stand, it was extensively amended during its passage through Parliament to remove glaring incompatibilities with international legal obligations that the United Kingdom claims to support as a champion of global human rights. But the end result is still a 2-tier limitation period for bringing civil claims that discriminates in favour of armed forces personnel, and a presumption against prosecution of personnel for many lesser offences after 5 years. Both look ripe for legal challenge under the Human Rights Act, and it's difficult to see how the Overseas Operations Act creates any greater certainty or improves the law. But it's a mistake to assume that this politically generated irritation is just confined to the Conservative end of the political spectrum. Labour and the SNP, as parties of government, have shown at times a marked reluctance to support the European Court and the Convention on issues that might be electorally unpopular. Political silence on the part of both these parties in response to the judgment in Hurst on prisoner voting was illuminating in this respect. Indeed, the Labour government, which enacted the Human Rights Act in 1998 as a reasoned response to the need for individuals to be able to assert convention rights domestically, seemed to lose its enthusiasm for the consequences under the growing threat of terrorism post 9/11. This event started a period of turbulent relations between the UK government and judiciary, initiated by the passage of the Anti-Terrorism and Security Act 2001. Part 4 of the Act provided for the indefinite detention of foreign nationals designated as terrorism suspects and thus required derogation from Article 5.1 of the Convention. The litigation resulting from the derogation, including the House of Lords judgment in A and the Home Secretary, declaring the legislation to be discriminatory and incompatible with Article 14, led to estrangement between the executive and the judiciary. The then Home Secretary Charles Clarke wanted a meeting with senior judges to ascertain what might be acceptable to them, and his suggestion was understandably rebuffed as compromising judicial independence. Labour backbenchers were emboldened to rebel over 90 and 42-day pre-charge detention, and the government saw its policies under sustained criticism. Worse still for the Labour government, a progressive emergence of allegations of United Kingdom involvement in serious human rights abuses by the USA and the litigation that ensued led to a breakdown in judicial trust in governmental standards of propriety and integrity in relation to that litigation. The decision of the Court of Appeal in Binyam Mohammed to order the disclosure of documents containing information that had been provided by the USA under the control principle previously upheld in our courts, guaranteeing their confidentiality, marked a definite low point. The basis of the judicial decision was that the material was already available to the public through US litigation, and disclosure was required in the interests of justice. The then government saw it, not unreasonably, as a disastrous blow to our reputation in the USA as a reliable partner, maintenance of which was seen as vital for our national security. Some level of tension between the executive and the judiciary can probably be viewed as healthy, particularly if it reinforces public confidence in judicial independence and indeed in the open debate on law that underpins parliamentary democracy. But as the judiciary is made up of human beings, such tension, especially if it's allowed to escalate, can induce feelings of being beleaguered and is thus corrosive of the mutual respect each branch of the state should have of the other. This was certainly the case after the Miller 1 case and the complete failure of the then Lord Chancellor Liz Truss to speak out against those newspapers who had branded the judges involved as enemies of the people, notwithstanding their entirely reasoned and reasonable judgment on an important point of law and constitutional practice. The understandable instinct when under such pressure is to push back. This in turn can reinforce the belief of some politicians that in a constitutional system that has been made increasingly rights-based, the judiciary might look for opportunities to overrule the principles of parliamentary sovereignty on which they see their power to govern as depending. Now, most lawyers, myself included, see this fear as far-fetched. But there are just enough examples of judicial statements in recent times to give this political concern some legs. In Jackson and the Attorney General in 2005, Lord Steyne famously suggested that, in exceptional circumstances involving an attempt to abolish judicial review or the ordinary role of the courts, the Appellate Committee of the House of Lords or a new Supreme Court may have to consider whether this is a constitutional fundamental which even a sovereign parliament acting at the behest of a complacent House of Commons cannot abolish. Another, in the same genre, was the obiter comment of Lord Kerr in our and the Work and Pensions Secretary in 2015 concerning the lawfulness of the benefit cap, when in a dissenting judgment he suggested that he could see no reason why the UN Convention on the Rights of the Child, an unincorporated international legal obligation, should not be directly enforceable in domestic law, on the basis that as the UK had chosen to subscribe to its standards by entering into a treaty, the government should be held to account in the domestic courts for their compliance. If Lord Steyne's comment concerns a doomsday scenario, which one might reasonably hope will never occur, Lord Kerr's proposition would be revolutionary in our dualist system if it were ever to be applied. Welcome as his comments may have been to some campaigning groups highlighting the gulf between virtue signalling political aspiration on the international stage and the domestic legal reality, the truth is that many such otherwise influential treaties would never have been signed in the first place if any direct judicial enforcement had been envisaged or was likely. Finally, in this list of examples of judicial goads to government is Evans and the Attorney General. The Supreme Court there struck down my own decision to exercise the veto provided for in clear terms in the Freedom of Information Act 2000 to overrule a decision of the upper tribunal. This was the Black Spider letters, in which the question was whether the then Prince of Wales's correspondence with government should be disclosed. I had decided to exercise the veto as my own conclusion on the balance of the public interest after a review of the issues differed completely from that of the tribunal. The Supreme Court didn't strike my decision down because it was unreasonable, but because the majority of the justices considered that Parliament could not have intended to give a minister the power to overrule a superior court of record, and that in the absence of the statute spelling out the power in terms that were crystal clear, they would interpret the statute to confine the ministerial discretion within boundaries so narrow that it made that part of the Act unworkable. The judgment revealed sharp differences within the court. Minority were satisfied that the power I'd exercised was clear, but a majority of the court were plainly deeply concerned at what they saw as a power improperly given by Parliament to ministers to overrule a court contrary to theoretical principles of the rule of law. They then engaged in some highly creative statutory interpretation to find a way of negating it. There's an oddity to this issue, because the history of the Freedom of Information Act shows no such intention, subversive of the rule of law, was ever intended by either the executive or Parliament. The original intention was to make the upper tribunal's decision merely advisory for ministers. It was only during the passage of the bill that the government agreed to make the powers of the tribunal determinative with a judicially reviewable executive override. The truth is that rather typically, in my experience of legislation, the consequences of the eventual legislative proposal had not been properly thought through. Using the upper tribunal in this way, whether in the original intention or its amended form, was plainly unsatisfactory. Whether that justified the Supreme Court decision is debatable. Equally, it's worth noting that in response, the government chose to do nothing to reverse the effects of the judgment. But looking at those three examples, now often cited by my former parliamentary colleagues as evidence of the deliberate encroachment of judicial power, I am left wondering whether the obiter comments of either Lord Steyne or Lord Kerr, or indeed the decision in Evans, would have occurred if there had been a greater relationship of understanding and therefore confidence between the judiciary and the executive in the first place. The sense of judicial concern at possible future, if not present, executive misbehaviour is palpable in each of them, just as was the breakdown in trust that saw the control principle undermined in the Binyam Mohammed case. The more government, or individual ministers, are perceived to neglect or even to undermine the rule of law by actions or words, the greater, I suggest, the temptation and therefore risk of judicial preemptive words and decisions. The government's current rhetoric against rights culture and its current legislative proposals on judicial review and human rights is being actively promoted by sections of the printed press and some think tanks. The Judicial Power Project run by Policy Exchange, for example, is intimately linked to a sectional interest of the Conservative Party that comes across at times as almost cultish in tone. In the case of sections of the press, an important driver is the impact of the way in which privacy law has been developed by the application of Article 8 of the Convention by the courts. This has then been translated into outright hostility to the operation of the Human Rights Act more generally. The enmity to any restrictions on their freedom was also clear in the resistance to the investigation of malpractices, including the revelations of serious breaches of the criminal and civil law by a number of media organisations over phone hacking and invasions of privacy. It led to the originally promised second part of the Leveson inquiry being abandoned by the government, which was wholly in response to pressure from sections of the press from whom it considered it needed support. And I have to say that as a politician on the front bench and in government, I saw at first hand the pressure and power that was exercised over prime ministers and leaders of the opposition to conform to what the owners and or editors of certain newspapers wanted. The contribution from Policy Exchange is far wider ranging and has been at times more nuanced. Its criticism of judicial power, for example, includes a list and analysis of 50 cases of concern, some of which date back to the early 20th century, and includes Leveson and Anderson in 1941, cited as an example of the Judicial Committee of the House of Lords wrongly sanctioning executive discretion rather than carrying out a proper statutory interpretation and considering the reasonableness of the minister's decision. Along with Lord Sumption's separate critique in his Reith lectures, the Policy Exchange list has produced some valuable commentary on trends initiated in recent decades by Parliament itself, trends that have undoubtedly facilitated the extension of judicial power further into choices inherent in administrative decisions, that you can argue might better be left to politicians. But whereas Lord Sumption's conclusion was to caution judges to exercise self-restraint, together with an acknowledgement that this restraint was indeed already happening more than previously, the most recent product of Policy Exchange's labours is a paper by Professor Richard Eakins, its prime academic mover, which advocates something far more radical. In The Limits of Judicial Power, apparently published to coincide with the start of the Truss administration, Professor Eakins demands complete withdrawal of the UK from the ECHR, the reform of domestic human rights law through the repeal of the Human Rights Act, leaving our country to rely on statute and common law as it was pre-1998. This proposal is intended to give us back our, quotes, traditional constitution. It requires making sweeping changes to principles of judicial review, including, perhaps predictably, a prohibition on the courts being able to review matters relating to, quote, our political constitution, or to interpreting ouster clauses and also imposing limits on judicial review in other contexts. But perhaps more tellingly, at the end of his paper, this legal academic invites government and parliament to abandon the process of independent judicial appointments derived from the Constitutional Reform Act 2005. He argues that the Lord Chancellor should be given the discretionary power to veto the appointment of any individual as a senior judge who might personally be minded to, I quote, undercut settled constitutional fundamentals, including parliamentary sovereignty, close quote, and in the meantime says that use should be made of existing powers to refuse to appoint candidates who have cast doubt on Parliament's authority to make or unmake any law. Short of posthumously refusing to appoint Lord Steyne to judicial office for his obiter reflections in Jackson, or for that matter Sir Edward Coke for his judgment in Dr. Bonham's case in 1610, it is rather difficult to see who this is specifically aimed at, as I can't think of any current judge who has questioned the sovereignty of Parliament to make or repeal laws. But the general intent is pretty clear: to control the judiciary by removing one of their key roles in our modern constitution, that of being able to interpret statutes in line with evolving general legal principles, a power which is quintessentially consistent with the way the common law system works, and to scrutinise the extensive powers used by ministers and public officials which affect the liberties and rights of citizens. As these executive powers have grown massively in the last century, so has the importance of there being an independent check on their use. The future offered by Professor Eakins looks rather dystopian. I've often spoken about the benefit of the Human Rights Act and our adherence to the Convention, and this talk isn't the place to repeat them in detail. But even Professor Eakins acknowledges in his paper that leaving the Convention would have foreign affairs implications in relation to the Trade and Cooperation Agreement with the EU. The Trade and Cooperation Agreement underpins our continuing relationship in combating crime and delivering national security and data sharing. He sees the problem of the Belfast Good Friday Agreement as solved by the simple expedient of leaving the Northern Ireland Assembly and Executive with a duty to comply with the Convention rights. He leaves entirely unexplained how this could conceivably work, either politically or legally, if the United Kingdom has, as he proposes, left the jurisdiction of the European Court. What he also chooses to ignore are the more general advantages that have come from our national adherence to and support for the Convention, including the transformation of standards of behaviour in adherent states, particularly those more recently subject to tyrannies, a major achievement of British soft power on the international stage. This benefit extends outside of signatory countries. Our willingness to follow the European Court judgment scrupulously in the case of the deportation of Abu Qatada to Jordan, despite the fury of the tabloid press and the more understandable frustration of the then Home Secretary Theresa May, helped ensure permanent statutory reforms to the Jordanian criminal justice system, which were both needed and welcomed, as well as success in having him deported from the United Kingdom to stand a fair trial in that country. And we've benefited here as well. It's enabled either in Strasbourg or at home landmark decisions which have challenged or halted practices which were once considered acceptable but would now be seen as unacceptable by the overwhelming majority of the British public, ranging from not separating elderly couples by forcing them to reside in separate care homes to the abolition of the practice of the blanket retention of DNA obtained by the police, and the inclusion of same-sex couples in new relationships of opposite sex in the new relationship on civil partnerships. One can, of course, argue that these matters should be dealt with by an elected parliament alone. But equally, our country shows, I think, maturity in the willingness of its elected representatives to think globally and to maintain a dialogue domestically and internationally with courts over standards of human rights, in governance itself, and to commit itself to respond to them. The sovereignty remains with Parliament. And any assessment of the irritations both the Convention and the Human Rights Act may at times have caused to UK politicians and government needs to factor in the advantages we derive from adherence. Moreover, as I mentioned earlier, in the last 12 months, I think when I wrote this, it said the last 12 months there had been 5 findings against the United Kingdom out of 1,100 judgments issued by the European Court. But as I say, I think the latest figure for the last 12 months is 2. We attract the fewest complaints per capita of any adherent state. But in fairness to Policy Exchange, at least Professor Eakins' goals are clear. In contrast, the proposals put forward by the Justice Secretary are not. I remain mystified by what in practice Dominic Grieve is trying to achieve with his Bill of Rights, unless it's some Machiavellian plot to create such variance between the interpretation of the Convention rights by our domestic courts and that of the European Court that the government is able to throw its metaphorical hands up in horror at the frequency of appeals to and adverse judgments from Strasbourg and claim popular support to withdraw entirely from the Convention. But in fairness, that's something which the Justice Secretary insistently denies is his intention. Leaving aside the unnecessary window dressing for the media on a new balance between privacy and freedom of expression and a right to trial by jury in England and Wales, most of the proposals for reform are about fettering the ability of our domestic courts to interpret the Convention in accordance with its own jurisprudence. The present bill also includes setting thresholds for access to our courts to bring a claim at all, and removing the power in Section 3 of the Human Rights Act for a court to seek to read a statute compatibly with Convention rights. Gone would be the just judicial dialogue between our Supreme Court and the European Court that has done so much in influencing the views of the European Court in ways that the government itself would approve. Examples such cases being Horncastle on hearsay evidence to Hutchinson on whole life sentences. Gone too the good ideas of Sir Peter Gross on the importance of developing greater civic and constitutional education in schools. In would come a ponderous system guaranteed to create more conflict with the European Court, so leading to more cases going there for final resolution. As Lord Mance has explained in great detail in his excoriating critique in his recent Thomas More lecture, what we will get if the Bill of Rights is enacted is just a recipe for further conflicts between the executive and both domestic and international courts. His lecture ought to be compulsory reading for every member of Parliament. And that, of course, is the basic problem. Most MPs won't know of Lord Mance's lecture, won't know that Lord Mance's lecture even exists, let alone read it. 60 years ago, the Commons was full of lawyers, some argue far too full, who were familiar both with the role of the judiciary and the operation of the law. They could, when needed, defend and explain the legal system, even when critical of an individual decision themselves. And then there was the Lord Chancellor, who not only a lawyer, but as the most senior member of the judiciary, was accorded a high status at the heart of government. The office was key to ensuring both a respect for the law and the possibility of an informal dialogue between government and judiciary that served our rule of law well. Today, despite the oath provided for in the Constitutional Reform Act 2005, the duty on the Lord Chancellor to respect the rule of law, defend the independence of the judiciary and ensure the provision of resources for the efficient and effective support of the courts has bluntly been treated as optional when it has clashed with the political views and ambitions of the office holder. Some ridicule was heaped on those in the House of Lords who, when the Act was passed, sought to amend it so that the office holder should remain in the Lords and be a lawyer. But they were right. Central to the Lord Chancellor's standing was that the office was not a route for the furtherance of careerist political ambition or, once gained, for further judicial advancement. This has now entirely changed, with successive Lord Chancellors gratuitously offering up cuts to their already overstretched budgets and sitting mute over proposals to deliberately breach international law. Similar issues have arisen with the law officers. Their role historically has been different. The legal advisors to government, and as such should be underpinned by observance of their professional standards as lawyers and a ministerial code that emphasises the need for the entire government to be acting and to be seen to act with propriety, even when faced with complex challenges. How then does this standard compare with the conduct of Suella Braverman, who appeared to have had no qualms whatever in endorsing an interpretation of international legal obligations that allowed the Internal Markets Bill to be introduced, when that interpretation was almost universally regarded as untenable and led to the resignation of both the Treasury Solicitor and the Advocate General for Scotland. Another example has been the propensity by the law officers to refer sentences of imprisonment for review by the Court of Appeal as unduly lenient under pressure from parts of the press, when it was clear on any objective assessment the sentences being questioned were not unduly lenient. Such cases were easily attributable to a desire for populist appeal. That sort of conduct undermines the trust of the judiciary in the government's standards of behaviour generally, and then makes any dialogue much harder. The lack of knowledge and understanding can also be seen in the progressive starvation of the Ministry of Justice of the funds needed to discharge its functions, now including not just the courts but also the prison and probation service. The gulf between the Lord Chancellor's oath to ensure the provision of adequate resources for the courts and the actual state of court buildings and facilities, including staffing or the amounts paid to practitioners for legal aid who work in those courts, is now startling. The days when the provision of justice was seen as a key social service of the Crown and the State seem long past. Reduction in legal aid provision from 2.2 billion in 2010 to 1.7 by 2019, on top of the decisions by previous governments to restrict the growth of its budget to well below the average of other departments, has led ultimately to remuneration rates for practitioners remaining essentially, as far as I can see, almost static for 25 years. While the quality of justice available in our highest courts may be unimpaired, the sense of our justice system becoming a whited sepulchre grows, and this too contributes to a reduction in respect for the rule of law amongst both the public and their representative politicians, as the system is seen as becoming slower and more dysfunctional. But this litany of problems perhaps also points to where solutions could be found. I don't subscribe to the view that a growing gulf of incomprehension between government and legal practitioners and between political practice and the law is rooted in some unbridgeably divergent interests. Rather, it comes across as the product of ignorance and a long-term neglect of the rationale underpinning the phrase the rule of law that trips so easily off the tongue of so many legal but also practitioners but also politicians. This is the result of taking its existence for granted and being complacent about it. As I've tried to illustrate, government by its legislative activity is trying to alter or get round legal obligations or trying to fetter the work of the courts, and in doing so is usually engaging in an activity which is counterproductive to good governance. In trying to circumvent legal principles, the executive is far more likely to create new obstacles than to remove old ones, and its lack of progress so far, come back to the Human Rights Act and when they first talked about changing it in the way they're now trying to do, points to a complete lack of evidence that it's helped to improve matters, even to its own satisfaction. A wise Prime Minister would abandon these schemes and take sensible steps to bring these two essential branches of government in a civilised society back into harmony. Restoring the traditional role of the Lord Chancellor in government would be a good start. It doesn't require him to sit again as a judge, which would plainly be impossible, but to return the office to being responsible solely for the good administration of the justice system, and importantly to remove the inconsistent burdens of prison and penal policy. Restoration of the centrality of the principles of observance of the ministerial code and of international legal obligations would be another, as would ensuring that the government, both through its departments and the government legal service, is seen as an exemplar of probity in how contentious litigation is handled so as to rebuild levels of trust with the judiciary. The judiciary, for its part, has come a long way in its senior members being willing to appear before parliamentary committees to explain their role and their concerns at how justice can be delivered within budget. It was clear to me when I was Attorney General that there is a willingness to engage informally with government by the senior judiciary and try to create greater mutual understanding. If these things were to be done and to be seen to inform how the government functions, I'm convinced that many of the government's frustrations in this area would disappear. Those occasional frictions that inevitably will remain would be seen for what they are, an entirely healthy manifestation of the interplay of the law, the courts, and the work of the executive. An awful lot of time, money, and effort currently being expended on pointless and counterproductive political projects for change would be saved. The government might also find itself the beneficiary of a calmer environment for its own decision-making. But to achieve this requires getting out of the echo chamber of demands for action, which politicians too often choose as their comfort zone, and really giving time and effort to reaching some objectively reasonable assessment of what is in our national interest. Sadly, I have to say today that on the evidence of the imminent return of the current Bill of Rights to the Commons, and the most recent comments of the Home Secretary, in breach, I would add, of collective cabinet responsibility that she favours pulling out of the ECHR completely, this is not about to happen any time soon. But we must hope for better. Thank you very much.
Now, I'm able to take questions from the floor. If you have a question, could you identify who you are or the group that you're representing, and speak as clearly as you can, because I'll have to repeat your question for those who are watching online so that they can pick up the full question rather than try to do so through the microphones. Yes.
Robert Whitfield. You raised so many items in your speech, Mr. Grieve, too many to go into depth now, but you mentioned Lord Stein's statement in the Judicial Review of 2005, the Jackson case. If one believes in the superiority of the common law, it will be supported in a clause or in a paragraph written by Sir David Owen in his book, published in 2021. I have a copy with me, you'd like to see it.
I'm not sure I followed that.
No, I'm not. I'm sure. The case from 2005 that you...
I have the quotation that Mr. Grieve gave in the Judicial Review,
from
the Jackson case.
Yeah.
Yes, from
One believes in the superiority of the common law as a hypothesis, then it will be supported by a paragraph in a book by Sir David Owen, published in 2021, which I have a copy of.
Well, I think if it's referring to Lord Stein's comment, it's right that there was a considerable debate in the 17th century as to whether, and certainly Dr. Bonham's case showed this, but there were also some other examples of whether, in fact, natural law might trump the power of Parliament to pass legislation. And I think Lord Stein was hinting that there might be certain circumstances which, as parliamentary sovereignty and supremacy was in fact a creature of the common law itself, the judiciary might have to rule that in fact a parliament was trying to do something which it couldn't do, even if it had enacted a piece of primary legislation. But as I said, it is a doomsday scenario, and we've never really come anywhere close to this. Our Constitution does make clear under the Bill of Rights of 1689 that there is the supremacy of the Crown in Parliament. And I don't think anybody seriously questions that. But I think the point I was trying to make in my talk is that we do operate within a framework. At the end of the day, you can have laws are man-made rules. They are there to help shape a society and to give it form and to show clearly limits, in some cases, of power. And if you disregard that completely and simply say that a parliament can do anything it likes, because it can, technically, I suppose, Parliament could vote that we should all worship the moon every Tuesday night. But I think it might run up against a certain number of people who said they weren't willing to do it. So one has to recognise that there's a limit to everything. And all I would say is that it is true that in this country we put great emphasis on parliamentary sovereignty, but there is a bit more to it than just that.
Thank you. On the front row, here.
Hi, I'm Jeannie. I'm just a master's student here.
Just a master's student. Carry on.
Thank you for the lecture. I wanted to ask, you brought up a Belmarsh Chahal or landmark national security cases. In a lot of these cases, there's a clear hesitance on the judiciary to rule on sensitive national security issues because they're aware that they don't have all the closed material or a lot of the sensitive policy issues that perhaps executive members will be able to consider. How do you think the balance should be struck in such national security cases?
Well, I think we've probably got the balance on this about right. We have significantly changed the way we approach some of these matters. We have closed material proceedings. We have special tribunals that can deal with these cases. Of course, they raise complex areas of tension. But actually, pragmatically and sensibly, and with occasional hiccups, I think we've got to a point where we've got a pretty good system. And of course, interestingly, it stood the test of human rights analysis, which shows, I think, the considerable flexibility in the way the convention is crafted. So, yes, there have been episodes along that route which have been difficult. The Binyam Mohammed case, I do think, I came in at the end of it really, when I was Attorney General, I do think there may have been a lack of understanding on the part of the judges who ruled in the way they did, just how potentially catastrophic the judgment was to the very close relationship we have with the USA, which undoubtedly is of massive importance to our national security. And I know with my hat on both as attorney, but also as chairman of the Intelligence and Security Committee. And the government was really concerned that it would lead to a reluctance to share information, whereas the UK and the US share information at multiple levels in the way, and also with the other Five Eyes countries, which is very important for us. And I think there was a lack of understanding. And I think it may be right that the judges were, perhaps understandably, rather appalled by what had been going on, because it's a very unhappy episode that occurred in terms of our involvement with the United States over detention and rendition. So there's an almost classic example, I suppose, from my point of view as a lawyer politician, of where tension creeps in. But we did get over it. So you've got to accept there are going to be these hiccups, otherwise the system wouldn't be working properly. But overall, do I think, looking at matters today, we have a credible system for dealing with complex national security cases? Yes, I do. There's one possible exception to that, which is our continuing difficulty to deal with historic allegations in Northern Ireland, but it's a rather separate issue. Are the security services happy with the system? Well, unless something's changed dramatically since I left office, ceased to be chair of the Intelligence and Security Committee in 2019, I think they are overwhelmingly grateful that such a system has been put in place. So I worry that we go along and try to reinvent the wheel. Actually, I think this system works well.
Thank you. It's a great question. Anybody else yes, of course.
Yes, I'm Meg Russell from the Constitution Unit in the UCL Department of Political Science. And obviously we're here in the Judicial Institute, and your focus has been the relationship between politicians and the judges. But I'm a parliamentary specialist, as you know, and often that's set up as a tension between, and you've mentioned it several times, parliamentary sovereignty and judicial power. I went to an event a couple of weeks ago at the Centre on Constitutional Change in Edinburgh, which was ostensibly about Parliament and devolution. And they were talking about the overriding of the Sewell Convention and so on. And I stepped in as a parliamentary specialist in defence of Parliament. So I don't think your argument really here is with Parliament, because Parliament doesn't even decide whether to overrule the Sewell Convention. And actually, if you look inside Parliament itself, and you look at things, just to give one example, like the EU, the retained EU law revocation and reform bill, but there are various other examples, Parliament itself is being shut out as a check on government. It is being sidelined. So I just wonder if you'd like to go a bit further and say, do you think there are some common themes here? And are there any common solutions?
Yes, there are some common themes here, undoubtedly. But Parliament is an assembly of people elected under party banners, but nevertheless people who are sent there to apply their own independent judgment to problems. As we saw during the Brexit crisis, when Parliament starts to assert itself in a way that the executive doesn't like, the executive cries foul and says, you can't do this. And this is where I came back to my comment about saying this extraordinary new constitutional notion that a government elected by a popular mandate is entitled to do whatever it likes unless Parliament decides to get rid of it, as we would now, by bringing it down on a vote of no confidence and having another election. And I don't actually think that's what Parliament is about at all. I think Parliament is about taking a range of options. After all, I, as a parliamentarian in 2018-19, didn't wish to bring down the government because in itself it wasn't going to solve the particular problem I was trying to address. But I did wish to see the government defeat it. And this seemed to send some of my ministerial colleagues into paroxysms of anger and frustration. And Parliament, unfortunately, and I think this is a significant problem, has allowed itself in the course of the last 100 years to become all too often just a rubber stamp to the executive. And because the executive controls Parliament, it gets into its head the idea that there are no constraints or limits on what it can do if it has a working parliamentary majority. And I think this colours some of the underlying issues it applies to the Sewell Convention, or it applies to, I think, at times, relationships or attitudes towards judicial decisions that the executive don't like. And it's really time for the executive to grow up. That's my attitude on this. They seem to me to show extraordinary immaturity about how a democratic system actually works in practice. Yes, it's right that the tectonic plates slide and you bring about change, and the purpose of having a parliamentary democracy is to bring about change without violence. But it has to accommodate ranges of views. And what has worried me more than anything else, and I think this is a modern phenomenon, it may well be driven in part by media and social media, is that we seem to be in a world where binary attitudes have become more and more commonplace. And we're suffering as a result of it. And quite a lot of my former colleagues seem to me to be essentially constitutionally semi-literate. I'm sorry to put it quite so bluntly, but they don't seem to see how the system works. I used to go into sixth forms and say, well, actually, Parliament is not a place where majorities impose decisions on minorities. It's a place where minorities come to accept, through the process of debate, majority decisions. If you don't have that, democracy falls apart. That's what happened in Northern Ireland. So people have to really do a little bit of thinking of how a working system of government evolves, and the judiciary play a key role in this. Of course, there may be occasions when judges get their decisions wrong. I can think of a number. But the question is, do you have a judiciary which understands government, and do you have a government which understands the judiciary? And if you have that, everything is going to work much more harmoniously and much better. And recent trends, and we'll come back to what I was saying, about how an understanding of law has diminished within government, possibly within Parliament as well, is, I think, very troubling. And in a country with an unwritten constitution, we've taken a number of props and knocked them out. And I do blame Tony Blair for this. I think the Constitutional Reform Act 2005 was an extraordinarily ill-considered piece of legislation. Not that there wasn't need for reform, but it just wasn't thought through. One of the consequences, I'm digressing a bit, is that it transferred onto the poor old law officers the task and burden that the Lord Chancellor had previously had in upholding the rule of law, which actually the law officers aren't probably best placed to deal with. And you've seen for yourself what's happened with an ignorance about the Lord Chancellor having an independent role within government, even though Lord Woolf and others did their very best to try and preserve it by the oath of office and trying to reinforce the point that the Lord Chancellor had to be an individual who was just a step back from the ordinary processes of government.
Thank you. I'm very conscious of the time, so unless anybody has another, you do have a question. Take one more question from the back.
Hi, my name is Philida. I was a master's student here in 2020 and I'm a court advocate at the moment. It ties on to your comments you've just made, my question. I can only imagine how difficult it is to navigate legislative processes without any formal legal training. So I'm just wondering, this is not something that's talked about very much. Why is it that we don't have a requirement that MPs be legally trained? And wouldn't that in turn help to address some of the issues you've discussed if everybody spoke the same language?
Well, I think if we were all lawyers in Parliament, I think we'd probably be a pretty awful place, actually.
Very nice places that are full of lawyers.
Yeah. But I think it wouldn't quite meet the need of what the country requires. Diversity in Parliament is very important. What I think has declined significantly is that Parliament used to have a lot of practicing lawyers. There are actually quite a few people with legal qualifications, but they often haven't done any legal work for a long time, and I'm not sure how much it rubs off on them. You know, witness the fact that the number of people who are lawyers were prepared. Well, one person who I like very much, but he was prepared to stand up and say that it was acceptable to breach international law in a limited and specific way, which I'm afraid is a view that I don't share. But you make a much more important point, that Parliament is not really doing the job for which we sent MPs to Parliament to do. Now, it may always have been like this, but I think it's got much worse. MPs arrive in the House of Commons, and the actual basis of what they're there to do is to challenge the government by asking awkward questions of ministers, or supportive questions, if that's what they want to do, to scrutinise legislation, to work in committees, and to work in select committees that may look at topics and put forward ideas to government as to how they might improve things. The problem is, this activity, whilst there are some people who do it assiduously, has very little media profile and very little resonance today. If you want to make your point, it's much easier to walk across the road and get a slot in a studio than to stand up on the floor of the House and make it. So they don't do it anymore, and you only have to look at the chamber and the number of people participating to see that we are losing the willingness to sit and listen to each other. So people come into the chamber and make a speech, and then they buzz off out and they don't stay for the rest of the debate. They've made their point, they might try and get their little headline. If you look in the 19th century, people sat through the debates and really listened to what other people were saying. This is no longer seen as a good medium, and as a consequence, the moderation that comes through debate is disappearing. Now, with that comes ignorance. And you are right about this, that a lot of MPs don't actually understand how the House of Commons works. So in this, I almost plead guilty. It was only in 2017-19 that I actually started to realise the extent to which the Commons Order book was in fact the ABC of the UK Constitution. Prior to that, because there were majorities, you didn't really bother. For the first time, I realised that the orders, the standing orders of the House of Commons are in fact they're not the mega written constitution, but they are its application in practice. And I started to use it, to the horror of ministers who were really upset. Actually, any member of Parliament can do that. But unless they're prepared when they arrive in the House of Commons to go and do a bit of training, and there is training available to MPs, I don't know how many of them take it up, and there is more. The House of Commons authorities have attempted to do more about this and to enable MPs to understand where they are in context. But I'm afraid the trend has been to MPs to turn into people who just want to do media and into social workers. Now, I enjoyed being a social worker in my constituency, and if I can do some good in that context, I'm very pleased I was able to do it. But there are now many MPs for whom it is the primary activity because it generates a bit of media interest in the locality. They're not at Westminster scrutinising legislation. And whilst I don't want to exaggerate what it was like in the 1920s or the 1870s, of course there were people in Parliament even then who weren't doing this, I think the number willing to do it is now very small. And you then get things like, for example, the willingness to rubber stamp all the COVID regulations, which Adam Wagner, in his excellent book, has highlighted just the extent to which Parliament, I'm not saying whether they should have done it or not, but the complete abdication of responsibility, picking up what Meg was saying earlier about the same with the Sewell Convention. It's the executive who decides to violate the Sewell Convention. It's Parliament that decides to let the executive violate the Sewell Convention on devolution.
Thank you. There we are. There's a training opportunity for your unit, for all new parliamentarians, maybe. Ladies and gentlemen, I'm going to draw things to a close there. I'm conscious of the time. We weren't able to get any questions from those watching remotely. Apologies for that. But perhaps we could just show our appreciation to Dominic again. I think you'll realise why. Just a few days ago, I listened to him lecture on how to deliver an effective lecture. And you can see why he was selected to do that at the time. And he's given us this evening a thought-provoking, challenging lecture drawn on his own unique experiences, drawing on history, rich with examples from much wider than I might have anticipated with just the Human Rights Act and Brexit. And I think he's exposed the longevity of this tension and the ongoing nature of that tension, and offered us some solutions. So a stimulating contribution to what is a really important debate, and therefore a very fitting lecture to be delivered as the first Leveson Lecture in the series. So perhaps we can show our appreciation one more time. Thank you very much.